Hi, this is a recap of a couple things that I think have been a little tricky under 1332, alienage, and also U.S. citizens domiciled abroad, who although living abroad do not become aliens. So, before getting into the nitty-gritties of these complexities, let's just recap the basics. So, 1332 has two requirements, as you remember. They are amount in controversy and complete diversity of citizens in one of four categories. As a comparison to 1331, remember, neither of these requirements says anything about the cause of action. That's totally irrelevant to 1332. All you need is complete diversity and amount in controversy. And we're going to focus on the types of diversity that involve someone living abroad. Okay, so here is 1332 SMJ. So these are the four categories. The last one, foreign state, actually suing a country, we're not really going to focus on. It doesn't come up a lot. Rather, we're going to focus on A2 and 3, as opposed to A1, which is the easy situation of a citizen of any U.S. state suing a citizen of another U.S. state when both are domiciled in U.S. states. Okay, so moving on. A2. So the first issue is, what's a citizen of a foreign state? A foreign state is basically a non-U.S. state. So we're talking about someone who is not having a U.S. passport. They are a citizen of Spain, Mexico, etc. That is someone we otherwise usually call in shorthand an alien for the purposes of 1332. So 1332A2 says a U.S. citizen, citizens of a state, can sue an alien. So there's the example, Illinois suing an alien, whether that's Canada, France, Ukraine, etc. However, the red part is an exception. So as you know, there's often a rule and then an exception. And the exception says that in some cases, someone who is an alien, someone who holds a non-U.S. passport, there are situations where there's no SMJ. What are those situations? It's the underlined part. It's saying that if you have a U.S. citizen who is on one side of the suit and there is an alien on the other side, but that alien happens to be lawfully admitted for permanent resident, a green card, and they are in the exact same state domiciled as the other party, there is no SMJ. That is the only situation where a permanent resident alien would not have SMJ. In all other cases, it would work. So, for example, if Mr. Moss, at the time he sued the landlord, was domiciled in Illinois, that would be Illinois versus, where were they from? I think Louisiana, and that's fine. But if at the time the suit was filed, Mr. Moss was domiciled in Missouri, or rather Louisiana, then it would be Louisiana versus Louisiana, and there would be no SMJ. That's what this is talking about. Okay. 1332A3 is talking about citizens of different U.S. states, and you have additionally aliens as additional parties. So this is basically the category of A1 plus you add additional aliens. So, oops, sorry. This is what it looks like. So Illinois versus New York are citizens of different states, and then aliens are additional parties on both sides. So this is under A3, not A2, because you have actually citizens of different U.S. states. And for this purpose, the aliens could be from any country, including the exact same country. So it could be Illinois plus Mexico versus New York plus Mexico, because for 1332, as long as you're not a U.S. citizen, your citizenship of another country just does not matter. Okay. Last funky thing, this is not alienage, but it sometimes people get it confused with alienage, and that is U.S. citizens domiciled abroad. what you need to understand is how these people don't fit under any of the 1332 categories. A U.S. citizen domiciled abroad, as opposed to temporarily living abroad, is not a citizen of a state under A1. Not because of what A1 says, but because of how that's been interpreted under Moss v. Perry. If you remember, the case says for 1332 citizenship, you have to not just be a U.S. citizen, you have to be domiciled in a U.S. state. So if you are told the U.S. citizen is domiciled abroad, you're not under A1. At the same time, if you are a U.S. citizen just domiciled abroad and have not become a citizen of another country, you also cannot fall under A2 or A3. So none of these categories work for U.S. citizens domiciled abroad. However, that does not mean you can't sue or be sued. You just can't be sued or be sued under 1332. As you know, there are other highways to federal court, including 1331, and also there is always state court, which is a court of general jurisdiction. So, where are we? Here's a recap. 1332 categories. I've listed examples of A1, A2, and A3. The first one, A1, citizens of different states. Plug in any two states that are different and you have complete diversity, which, although not stated in the statute, is required as interpreted by the common law. The second category, Illinois versus an alien. That's basic alienage jurisdiction. And then the third category is Illinois plus an alien versus Wisconsin plus an alien. So it's basically the first category, except you add aliens on both sides. So what's not within 1332? So if you have Canada versus Spain, you should notice that there is no category where it's just alien versus alien. And if you actually go back to the Constitution, Article 3, Section 2, you'll notice that's not a permissible category. Similarly, we talked about U.S. citizens domiciled abroad versus Illinois doesn't work because U.S. citizens domiciled abroad is not one of the categories. Last thing, U.S. citizen domiciled abroad versus an alien also doesn't work because U.S. citizen domiciled abroad is neither an alien or a 1332 citizen of a state. So hopefully that helps with your understanding of these categories. That's all.